In this video, we're going to talk about the case relating to duress to the person, Barton and Armstrong. In this case, Barton and Armstrong were shareholders of a large company, and both of them were fighting for control over it. Eventually, Barton ousted Armstrong from the company, and therefore was in the process of negotiating Armstrong's exit agreement. Since then, Barton had received multiple threats from Armstrong and was compelled to enter into an agreement with him, which was very favorable for Armstrong. Those threats included death threats to him and his family, phone calls past midnight, as well as hiring a hitman. At one point he said, "You had better sign this agreement or else." The case went all the way up to the Privy Council, and whilst the judges there disagreed on certain issues, they were unanimous on what the law is. Principally, they held that the effect of duress to the person on a contract is to make the contract voidable, and for such duress to the person to apply, there must be two conditions. Firstly, there must be a threat of violence made to the person. This is the illegitimate pressure requirement. Secondly, the threat must have been a reason to enter into the contract. This is the causation requirement, which, it should be noted, is different from other types of duress. The majority held in this case that the contract between Barton and Armstrong was indeed voidable. Lord Browne-Wilkinson and Lord Simon held that the first step required of the plaintiff is to show that some illegitimate means of persuasion was used. In the case of duress to the person, this requirement is almost invariably satisfied due to the threat of violence caused to the person. The next step would be to establish the causal relationship between the illegitimate means used and the action taken by the other party. The illegitimate means used was a reason, not the reason, nor the predominant reason, nor the clinching reason why the complainant acted as he did. In other words, it need not be the only reason or the most substantial reason for why the complainant entered into the agreement. A decisive answer to the question of whether the illegitimate means, i.e. the violence threats, was a reason for the claimant to enter into the agreement is not obtainable by asking the question whether the contract would have been made even if there had been no threats. And this is because even if the answer to this question is yes, that does not prove that the contract was not made because of the threats. Again, this emphasizes that it need not be the but-for reason, it only needs to be a reason. This principle was echoed by Lord Cross, who held that if Armstrong's threats were a reason for Barton's executing the agreement, Barton is entitled to relief, i.e. he is entitled to avoid the contract, even though he might well have entered into the contract if Armstrong had uttered no threats to induce him to do so. It was for Armstrong to establish that the threats which he was making, in fact, contributed absolutely nothing to Barton's decision to sign. And as we know, in this case, Armstrong had failed to prove that. Though it may be that Barton would have executed the documents even if Armstrong had made no threats, nonetheless, the threats and unlawful pressure in fact contributed to Barton's decision to sign the documents. How much it contributed is not relevant.